Hi, and welcome to Legal Angle, the policy roundtable where we discuss issues in the news
from a legal perspective.
I'm here with my friend Matt Yaspin. Matt, great to see you.
Ken, nice to see you. Always a pleasure.
And you know what this is?
Tuesday?
It indeed is, but we're always here on a Tuesday. No, it's our first show of the new year.
Oh, yes, it is.
Where are the fireworks? There will be fireworks, I hope.
I think we'll put them in post-production.
Okay. I think they'll be figurative fireworks, maybe.
Yeah, they're already there.
Yeah, they're built right into the model. So, of course, here we are in Legal Angle. We've got issues in the news, which, as we mentioned, we'll discuss from a legal perspective. But, man, there's so much happening, right?
Well, Ken, that's one of the great things about the topic we have for our show. Issues in the news. There's always news. There's always something happening, and we can always look at it from a legal perspective.
But the thing here is, even things we've talked about before, they're newer news. And in fact, I'm really excited because I'm going to get to ask you in a minute about an update to one of the topics we talked about on our last show.
That does happen. It is fun. And
yeah, remember we were stuck in a pickle? Let's do it. Shall we do it?
We should. We'll dive right on in.
All right, let's go to our first topic.
It's a briny subject, pickles.
Yeah, so as our audience will remember, last episode we talked about Grillo's Pickles and their trade secret lawsuit saying their formula had been stolen, and they were suing this other manufacturer of pickles. It was a briny situation.
It was.
And so Matt, what's happened since then? Has the plot thickened, or so to speak?
I wouldn't say that it's thickened, but I would say, Ken, that some of the people involved are getting a little salty.
Ooh, I see what you did with that.
Thank you. So Grillo's Pickles, Boston-based company, originally founded, I think, in 2008 on the streets of Boston, acquired in 2021, still going. Makes pickles. In our November show, the last show that, as our regular viewers will know, we talked about how they were suing their co-packer, or the packer who they had make and pack pickles for them following their trade secret protected recipe.
Right, wasn't there something about Whole Foods was buying the competitor's product instead of their product?
Their competitor was making the pickles with the same recipe, allegedly, at much higher volume for lower cost.
Allegedly.
And selling them at lower cost, or selling them to wholesale.
Somebody stole their secret formula. They can't be happy about that.
They were not, and they sued them. Now they've also sued Wahlburgers.
Now Wahlburgers, they don't make pickles; they make burgers, right?
That's right, burgers and other food. But
how do pickles figure into this?
The gist of it is that Wahlburgers is selling and advertising the Patriot pickles as coming with...
That's the infringing one, or allegedly misappropriating trade secret one?
Patriot Pickles is the name of the, I believe, New Jersey-based company that's been manufacturing Grillo's Pickles.
So they were making Grillo's Pickles, stopped making Grillo's Pickles, started making their own pickles using, allegedly, the Grillo's formula?
Yes, although I'm not certain that they'd stopped making Grillo's. I think they just were making Grillo's and then also started making their own. Are you sure
Grillo's is still letting these Patriot guys make their pickles?
I think Grillo's put a stop to that.
Yeah.
In a
I
jiffy.
mean, at this point.
Yeah.
So at this point, what is Wahlburgers doing with these knockoff pickles?
They're selling them, the Patriot Pickles, and advertising.
As a separate thing? Are they slicing them and putting them on their burgers?
I believe it's on their food, with their food. I could be mistaken. It might be that they're also selling them like you could buy a jar of pickles at Whole Foods or the Star or wherever. I don't think that's the case, but
maybe you can get a pickle with your burger. You just get one pickle.
I guess it's possible. I mean, I love pickles. I would just...
I'm always... Usually they do a spear, though. They give you a quarter of a pickle.
Usually, yes. But I've been known to impulse buy pickles. So I don't want to rule out the possibility that Wahlburgers is selling them, because I might be suckered into buying them. Like a candy bar. Yes. But pickles.
Well, if you're on a diet, pickles are very tempting because they're so low in calories, of course. But the thing is, they're loaded with sodium. So if you eat like the entire thing of pickles, unnatural things will happen. Anyway, go on.
Ken, folks come for the news and legal angle topics. Stay for the strange medical advice. Just kidding. None of this is medical advice. We are not doctors.
We're not giving legal advice either.
No, we are lawyers, but not your lawyer. Okay. Grillo's Pickles.
Unless you're a client and you're watching, of course.
Well, then we would be your lawyer.
One of us would.
One of us. Grillo's Pickles, trade secret misappropriation. They're now alleging that Wahlburgers is deceiving customers by making comparisons between the Patriot pickles, which allegedly are the same recipe as Grillo's.
Those are the knockoff ones, the pickle chips, as it were.
Right. And Grillo's pickles, and saying that the Patriot pickles are better in some ways. Tastier, better,
they're saying they're
better in
so that's
sodium.
like a false advertising claim, isn't it?
Yeah, false and deceptive advertising. They've
layered that on top
of the trade
of
secret
the tasty trade secret
Yes.
misappropriation. They've got a nice layer of false advertising claims.
Yeah, it's almost like, you know, say you're making a sandwich and you put a condiment on, and then on top of it, you want something salty and a little crunchy, and you look for some pickle slices. And you just slap them right on.
That could be exactly what they're doing.
Yeah, it's like, well,
so where's
in a
this
way, that's
going?
what amending a lawsuit is like, right? It's
Right. Oh, yeah.
making a tastier burger.
So next time I amend a complaint, I'm just going to be saying, I'd like a little cheddar on that.
If you start channeling Dennis Eckersley as you describe your filings to the judge or the clerk, I will pay good money to see that.
So I want some hair on that claim. Claim number 3's got some hair on it.
Your Honor, this motion is cheese. It's got lots of cheese. It's really hairy cheese.
And the defendants are definitely going to go go to the yard.
We move to strike the hairy cheese. All right. I think we need to move on.
That was a walk-off. Let's walk off right now before we...
I think we're calling it. Yeah.
Okay.
We're invoking the mercy rule.
All right.
So, what's up next? Let's talk about...
No, but just to be clear, though,
Oh.
where is this litigation going? Do we know what's next?
I'm looking for a pickle-related pun. We don't know what's next.
Okay.
Yeah, but stay tuned, sports fans,
Yes.
because we'll be back with whatever happens in the Grillo's saga.
And yeah, I'm not going to say it. I'm not going to say it.
Mercy rule, Ken.
Yeah,
We're moving on.
we're moving on. I'm not going to say it. All right. So yeah, let's go to our next topic.
Yeah.
What's our next topic?
So next up is of mice and copyrights. Now, I know what you're thinking. How dare I invoke the name of the title of Of Mice and Men, a great Steinbeck novel, in our TV show? Well, it's because we're always making puns, and you'll see the hook. Invoking
At least
the title.
you didn't say Of Mice and Ken, which is what I get sometimes.
Invoking the title has no copyright implications. We're making a pun. But our regular viewers will probably know that starting 2 years ago, every January 1st, items started rolling into the public domain.
And we've talked about them at great length.
Right.
Like Winnie the Pooh is like one, and now I believe is Tigger. I think Tigger this year is in the public domain.
I think so.
Now
And-
we've got
and
Winnie the Pooh and Tigger.
Well, you know,
too.
there was, what was it called, like Blood and Honey?
Yeah, that was because Winnie the Pooh went in last year.
Winnie
yeah.
the Pooh went into the common and public domain at the start
Right.
of 2023.
Yeah, we did, this is the beginning of the year. We didn't do our list of things going into the public domain.
No, we
Oh,
didn't,
well.
but this is our January show. So even though we don't have a whole list prepared of what's in the public domain
We should
now,
yeah.
we can do it later. The first version of Mickey Mouse is now in the public domain.
Yeah, and
Rejoice.
Mea culpa. I think I did the math wrong, and I claimed in last year's first show. Sorry about this, audience. That Mickey was going to the public domain last year. But
Yes,
yeah, I was.
we did.
It was my fault. I'll take
Yeah.
full responsibility for premature Mickey Mouse release.
Yes, well, thank you. We'll allow it. And now that we're correcting the record, it is this year, as of January 1st, 2024, that the first version of
We did
Mickey
get the
Mouse.
scoop on this. We talked about it before everyone else.
That's right. The first version of Mickey Mouse, that's Steamboat Willie, has now entered the public domain. Now, I don't think the phrase Mickey Mouse, that character wasn't called Mickey Mouse. It was Steamboat Willie.
And it wasn't the modern version of the character.
It's not even the 1930s or 1940s versions of the character.
But it's recognizable as Mickey Mouse.
It's similar to Mickey Mouse. Now, there's a lot more we can talk about, and maybe in our next show we'll go into it. But what I wanted to go into here was the specifics of what has happened now and what can people expect to see now with Steamboat Willie.
You had a question for me involving pizza, perhaps?
I did, because as you may know, we just snacked on a little pizza. So is there any particular connection between Steamboat Willie and pizza now?
It's funny you should ask.
Is it?
Because in in Pittsburgh, Pennsylvania, not known for its pizza necessarily, but there's a popular pizza shop.
Let me just interrupt you to say, folks from Pittsburgh, please do not come after us for this. We're sure your pizza's terrific.
Yeah, but it's not like what it's famous for, you know.
All right, just.
All right. I happen to love Pittsburgh.
I don't need the Steelers fans coming after us, Ken.
All right, fair enough.
Don't disparage anybody's pizza.
I'm not. No. I'm not saying that it isn't great. I'm just saying it's not like, well, Philadelphia's cheesesteak. What is Pittsburgh known for? I have friends in Pittsburgh. I'll text them after the show.
Rivers and bridges.
Yeah, and the bright yellow bridges are lovely.
Yeah.
Yes.
Pizza.
Okay, so there's a very popular pizza place in Pittsburgh, and what they've done is they have put Mickey Mouse, the original Steamboat Willie version of Mickey Mouse, on their receipts. They're using that image because they think, hey, it's in the public domain and it's free of copyright, so we can use it.
So I know we got a graphic of this because we grabbed a photo that somebody posted on Twitter of a receipt, and we'll throw it up on screen for you folks.
Oh, there it is in the lower right-hand corner.
You can see it there. Yep.
I wonder if we can zoom in. We probably can't zoom in.
I didn't think to do that. But if you look close, you can see there's Steamboat Willie on the top right of your screen, and right beneath it is a photo that a user took of the receipt from this pizza place with that Steamboat Willie image.
5107 Penn Ave. If you're there in Pittsburgh,
yeah, drop
try
by.
it out.
Send us a photo with your receipt while you still can, or keep it because, well, Ken.
Yes.
So you just
Do you have a legal question about this, Matthew?
I do, because my understanding is that Steamboat Willie there is now in the public domain with regard to copyright, which means that you can make
you
can make fan fiction, right?
Is your question for me? Is this okay what they're doing?
I'm getting to it because it's copyright. It's in the public domain for copyright. So I could write, bawdy limericks.
Well, people have
about
actually
Steamboat
made
Willie.
these cartoons. They've made their own Steamboat.
You could make
with
Steamboat
AI
Willie cartoons. You could make a Steamboat Willie movie or a TV show. Go for it, right? That's
right.
That's true. That's true, right?
You can do a lot with Steamboat Willie now, absolutely.
So can the pizza shop do this?
Well, funny you should ask, Matt, because copyright law isn't the only legal protection that's being asserted over this image. Disney's lawyers are very clever, and so what they've been doing for years now is they've been taking this image, and in fact the animation of this image, the first few seconds of the Steamboat Willie video, and they've been using that at the beginning of their other video products as a trademark. So in other words, what they're asserting is that that image of that cute little mouse with the two circles and the big black ears, that image is a Disney trademark. When you see that image, you think, oh, I must be seeing a Disney branded product. And they have and trademarks do not run out except when you stop using them. They can be abandoned, but they can last forever, of course. And what that means, unlike patents or copyrights, what that means is that that image is still protected for use in conjunction with the sale of goods or services. In other words, for branding, for brand identification purposes. So what that means is this pizza place is saying, we're using this to identify our brand, Spack Brothers, and if Disney cares to venture into this, they're going to have pie in their face. Because, I mean, well, their pepperoni will be sliced and diced. Because no, they cannot use Mickey Mouse as their trademark. Now, they could put this image on the wall as art, but they couldn't use it to identify their brand.
Ken, Olive, to hear what you're saying, because let me make sure I understand this. You're saying that it's true that anybody can make a Steamboat Willie art, creative work, right?
So if you're
painting,
here's the way to distinguish it.
Let me just say,
yes.
Paintings, photos, videos, TV shows, books, anything.
You can make Steamboat Willie the Axe Murderer, which I think someone is actually making, by the way.
I believe that's true.
And there's a video game, too, I think they're making with Steamboat
Excellent.
Willie.
But you can't put Steamboat Willie as your trademark on selling whatever you want to sell.
Right. So here's the key to identify. People ask all the time. They say, Ken, how do I know if what I'm doing is using an image? I've got this little logo. Am I using it as a trademark, or am I using it as something that would be copyrighted. For example, if I put some art on on a shirt, can I protect it as a trademark? Well, it's very simple. Are you using it to identify the brand of the other thing, or is it the thing people are buying? I'll give you an example. If you've got a cute picture and you make it big and you put it right in the middle of the shirt, people are buying it because they think that's a nice looking picture on the piece of clothes. If you've got a little one, right, like a little alligator, say, or some other little piece of art above the pocket or on the chest, then you're identifying the brand. You're saying, this is quality workmanship, this is my brand of clothing. So, and by the way, this is with T-shirts, the Copyright Office is very clear. If you've got a big, I'm sure.
Yes.
Well, they will not accept a specimen if it's a big piece of art right on the front, because you're buying it for the art then. It's not,
Right.
So what they're doing here looks very much like trademark identification to me.
The pizza shop.
The pizza shop. It does not, I think this is a slam dunk case for Disney if they want to, sharpen their butcher's knives and go after, this blind mouse.
Yeah, I agree. I think the only possible hurdle for Disney in trying to enforce against these people, besides the,
People will
possible,
laugh them.
besides the possible embarrassment and mockery that they will get, is that trademarks apply in connection with goods or services,
Right.
not just the mark itself. And
Yeah, that would be a big issue. We've talked about before, you've used the example of Delta Tools, and of course
That's
there's
right.
Delta Dental, Delta Airlines. There's a million things that start with Delta Faucets. Lots of different companies can use the name Delta as a trademark, but, and here's the big but, they can only, if you got a company that is so ubiquitous, like Disney, that is selling lots of different things, they have Disney resorts, and they have Disney.
That's right.
That's the problem. It's because they are selling pizza.
That's exactly
and
it.
that's why Disney's got a slam dunk case. Because if Disney were just a manufacturer of, I don't know, they just made movies and nothing else, then this guy would say, I can use this thing for pizza.
Right.
But it is.
But if anybody says to themselves, does Disney sell food?
Mm-hmm.
Well, look, there's Disney theme parks, there's Disney cruises, there's, I believe, Disney-themed restaurants, and at all of those places, they sell
there's
food.
two things the courts look to, and the USPTO looks to, right?
Yeah.
They look to likelihood of confusion
Yep.
and actual confusion. And I got to say, if I saw that, I'd think, oh, it's a Disney affiliate. They licensed it from Disney.
Yeah.
Disney's endorsed this pizza. It's, it's
Yep.
whatever you expect in Disney pizza. I don't know. Overpriced, maybe. I have no idea, but.
You lay the pepperoni out so it makes a little mouse head shape.
Yeah, no, I mean, presumably they have some quality associated with their brand, because you would think Disney wouldn't endorse a product that was shoddy, because they're a big company. And so you think, oh, Disney's branding this, it's okay. Now, Disney, as we talked about once before, I think, has branded some crazy things. I remember that bag of apples I bought that had, Disney character stickers on every apple. I mean, that's one way to get kids to eat their fresh fruit, I suppose. But
it's also a smart play by Disney because it expands their brand and what consumers think that they might sell.
right, and gives them broader protection.
That's right. It makes it much harder for people to sell anything and then be able to argue, well, Disney doesn't sell anything that people would confuse with, the sneakers that I want to sell.
Say what you will about Disney's movies, cartoons, rides, anything else. They've got some excellent lawyers there. Really, hats off to their legal team.
Yeah,
Man.
don't tangle with the mouse.
Yeah, right.
I'd rather be chased down by the Pittsburgh Steelers.
Yeah, right, exactly. Oh, than by Disney any day of the week.
Oh, yeah.
Absolutely. All right, let me ask you about another topic, Matt.
Yes,
you ready to
please.
move on?
I am.
All right, let's talk. You know what? It's January, it's a new year. Well, you know what happens in January, of course.
People go back to the gym for the month?
I was thinking they eat their leftover Halloween candy that's been sitting here, because they know it's going to go bad soon.
If you're my family, you might want to try to balance eating the leftover Halloween candy with occasionally going to the gym before you give up on the gym and just go back to eating the leftover Halloween
Fair, but I mean, I think people are thinking, well, October 31st, give it 2 months, January 31st. They want to go in. So what are they going to eat? They're going to throw out the stuff that was kind of sketchy to begin with. They're going to go for the good stuff, like the Kit Kats, the Reese's Cups. Did somebody say Reese's Cups?
Somebody did.
And then
if you still have any left, because in my house,
yeah, they don't last long, right? And then someone's going to open up those Reese's Cups, and then they're going to say, I've got a problem with this Reese's cup. I think I'm going to sue Hershey's Corporation.
I've been misled.
Yes, and why would they say that, Matt?
So this is a topic that was suggested to me by my daughter. So shout out, Juliet. Thank you for bringing this to my attention.
Good job, Juliet. Now your dad owes you one. I think he at least owes you a pack of fresh Reese's. Don't let him give you this.
Absolutely. So what's happened here is that Reese's has branched out from making just the peanut butter cups to lots of other.
I'm pretty sure they made other products for a while because there was a movie with a
I
guy with a
understand.
wide head. You've seen E.T., right?
I've heard of it.
Yeah. Like
but-
the Reese's Pieces, you know.
And not super recently, but not just the Reese's Pieces, but the peanut butter cups. They make in a bunch of shapes now. They make hearts. They make football
They
shapes.
make the cute little ones too, right?
Yeah, they make the mini ones, but those are still cup shaped.
I see what you're
But
saying.
they make a variety of shapes. And as you can see up on the screen, they make, among other things, bat shapes. And what do we get up there? Pumpkin shapes.
They also make dark chocolate ones, which I highly recommend.
I wish I didn't know that, but thank you. Now I'm going to have to
Write
go
that
find those.
down. Try them
Write it
out.
down. Dark chocolate. Okay. The thing is that they make these shapes, and as you can see on the packaging, they make the packaging look like cute little animals, right?
Oh, that's adorable.
'cause these were made for
There's
Halloween.
a bat. Oh, well, that one's not an animal. That looks more like a jack-o'-lantern.
That's right. It's a jack-o'-lantern. It's a pumpkin shape.
Those are cute.
These were made for Halloween, and I've.
So what's wrong with that? Why should anyone sue them for making adorable characters on their cups?
Somebody has sued them for false advertising, saying that the candy, when you open it and take it out of the package, doesn't have the cute little eyes on it that's shown on the package now.
Well, that would be very disappointing. You see that package, you expect the
Well,
thing inside the package to match
at
what's
least
on the
this
package.
one person, who we're going to refer to as a Florida woman.
Usually we talk about Florida man, so that's
Usually we do, but this is apparently
so this
Cynthia Kelly.
okay,
has
but
sued.
she did not get eaten by an alligator, so that puts her one step above the Florida man.
I
who's
got to say,
usually-
my information is a month old, so anything could have happened. She sued Hershey's, the parent company,
yes.
and one of my favorite topics, Hershey's. She sued them for false advertising.
And that's because when she opened, is this an adult who is really upset over this? I mean, it's like I can see it like a little kid.
The article that I read about this doesn't say her age. I'm going to presume so, but I don't know that for a
I
fact.
mean, I could seriously see being like 5 years old and going, oh, look at the cute picture, and oh, that's disappointing. But come on, I mean, you're an adult. You're just sneaking it on the side. You don't want the spouse or the kids to see your these things down.
I eat them over the sink and try and hide the trash. so
Yeah,
nobody
you don't. You
notices.
like, whoa, is there one missing? I don't know where it went.
Yeah, I blame the dog.
The dog's like, I'm not taking the fall for you this time, Matt.
No, she's smart. So the point is, she sued them for false advertising, saying that she was harmed and deceived into buying these candies because of the cute faces. And she noted that in the past, they sold these without the cute face ornamentation on the packaging.
And she bought them anyway.
Presumably. But now the packaging has changed, and that's where she feels she's been harmed.
So
because the packaging is now extra cute, and the candies don't
Did she
match.
buy more than she would have if it had the old packaging, or did she pay more? I mean, how was she harmed?
Ken, I'm just here to report.
Well, let me ask you another question. You can report on this. How much money in damages is this nice lady seeking?
I was hoping you'd ask, Ken. How much do you think it would be harmful to you if you had bought some candies? Bear in mind, these things cost, depending on...
$3 maybe?
Yeah, depending on the size of the package you buy.
Well, these are little individual packages. They might be less than that.
Well, they might be sold in a big bag. So
okay.
Say you
might be spending $5.99 on a really big bag of these.
You could, or $11.99 if you buy a giant bag to give out on
Oh,
Halloween.
I don't know if these specialty ones come in those giant bags, but okay, I'll
don't know either.
All right.
Further research is called for. Ken.
Yeah. So what is she claiming? Emotional distress or something, or?
She's claiming that she's been harmed economically, and I.
Okay, well, the most you could be harmed economically is if you looked at it and
Right.
said, I can't eat this, and threw out the bag, and then you'd know, and you'd never buy it. So it's, Matt, in your example, if it's $11.99, I'd say the most damage she could conceivably get would be $11.99 for this false advertising.
Right,
claim. And what is
right.
she asking for, Matt?
Well, it's funny you ask, Ken, because it's more than that. She's asking for a cool $5 million.
So I guess
That's
maybe
million with an M.
So in
US
Massachusetts,
dollars.
I can understand that she would want more than her actual harm to dissuade the company from doing this false advertising. You can have punitive damages, but my understanding is punitive damages in most states can't be more than 10 times actual damages. So if her actual damages are $11.99, we're talking maybe $120 in punitive.
Well, this was filed in Florida, and I don't,
All right. I do not know
Florida
their
statute
consumer protection
limitations on that. But I will note that $5 million is just about the amount of the verdict in a recent
Yeah,
lawsuit.
that sounds familiar.
Yeah.
Was there somebody orange, just like that package? There was an orange gentleman who did some bad things.
Yeah. $5 million is the amount that Trump was found.
Was he singing around the holidays? Was he caroling by any chance?
Oh, that's yep.
Sorry.
Liable to E. Jean Carroll, the writer, for defaming her in the
No,
first.
but in all seriousness, I mean, he defamed her by saying he didn't sexually harass her, and of course,
and called her a liar
Yeah,
and said she was
and
crazy and out of her mind.
but the jury found that he had actually sexually assaulted
Right.
her, and he was liable for $5 million. That's right.
Right, in the first lawsuit that she filed against him. Now, that is the same amount that this Florida person is saying she's been harmed
Right.
by
I'm going to
the
go out on a
candy-
limb.
by the candy not matching the packaging. Just bear in mind, to the full extent of my knowledge,
but
she
E.
makes
Jean Carroll
no
actually
allegation.
lost-
She makes no allegation
But she actually
that
lost
the
like a
candy was
TV
bad.
show or an advice column, E. Jean Carroll. She had real damages as a result. And then, of course, as we know, this week she got
Yeah.
83 and a third, .3
Yeah.
million.
But
in the second
that's true,
lawsuit.
Ken. But meanwhile, Cynthia Kelly feels that the packaging
Yeah.
doesn't look like the candy.
Good luck, Cynthia.
Okay.
All right.
That's all I have about this lawsuit.
Yeah, no, I mean, I think that's a sweet little story. Thank you for sharing.
And I'm very appreciative again of my daughter to bringing it to me.
Yeah, no,
because wow, just amazing.
I think some people, I don't know, are just a little bit much. I mean, yeah, I get that it's false advertising, but I don't think you're scarred for life by opening that package and not getting the candy you wanted.
Yeah, I mean, realistically, you kind of get extra chocolate relative to the packaging because the packaging shows a little, regions
cut out,
without
right.
the chocolate, and you still get that chocolate
Well,
coating.
maybe you want that ratio. I mean, maybe the enjoyment factor is better with the lower chocolate to peanut butter ratio.
Perhaps Ken, the judge, will let her amend her complaint to allege that as well.
Less satisfaction.
Yeah.
I'm still not. I think you could add all the cheese you want to this complaint, and it's still not going to be a filling meal.
We probably should have left this topic off because I cannot stop laughing about it.
Matt, we better stay away from the food topics for the rest of the show.
I think so.
Let's move away.
All right.
Slowly
We've got
back
something
away.
that's not food related and is a little more serious, I think. We'll let you be the judge, dear viewers. So next up, Scotus, the Supreme Court of the United States, and the 14th Amendment. Why the 14th Amendment? Because there are a bunch of lawsuits or actions that have now led to lawsuits in various states in the country regarding what Section 3 of the 14th Amendment means.
Meaning, if you engage in insurrection, you can't hold one of the highest offices in the land?
Or any of actually a few hundred, several hundred.
Yes. One of the few hundred.
Yes.
One of the few hundred.
Yeah, so we
several
put
hundred.
Section 3 of the 14th Amendment up on screen. You can read it at your leisure. You can find it. It is free of copyright. You can do whatever you want with
As
it.
with all federal documents.
Yes, you can make derivative works. You can write creative stories about it. It says, as you just said, that if you've engaged in insurrection or given comfort, what's it say? Given aid or comfort to the enemies of the United States, you can't, and you'd previously taken an oath, and you'd previously taken an oath as an officer, you can't hold office.
Matt, I lost track. Who's interviewing who about this one? Am I asking you? Or
I'm interviewing you.
Oh, okay. All right.
So Ken, why the intro? Why the topic? Why is this in the news at all?
Well, there's this guy. You're not going to believe this, but there was this real estate guy from New York who allegedly got elected president, I believe. And I thought it was all a bad nightmare, but apparently it actually happened. No. So anyway, so Trump on January 6th and prior to January 6th, encouraged people to sabotage the lawful transfer of power from Donald Trump, who had lost the election, to Joe Biden, who had won the election. And he was very upset that his vice president wouldn't participate in the sabotage and suggested that his supporters might want to, kill him.
By hanging, specifically.
Yeah, hang Mike Pence. He liked that chant.
That was the chant that he really...
And he was very well aware that people were going to potentially do violence to the members of Congress who were involved in certifying the election results on January 6th, as the Constitution, or as the federal law actually requires, because that's the date set by law. And so, as people know, lots and lots of the rioters that day, the insurrectionists, were charged and convicted of crimes, and presumably none of them can hold office in Congress. So in 2 different states, officials have said Donald Trump cannot appear on the Republican Party primary ballot. Specifically, a judge in Colorado, the lower court actually said he could. The lower court said, yes, he participated in insurrection, but president's exempt from this rule, is what the lower court said. And the highest court in Colorado, the Colorado Supreme Court, said, you know what, lower court, you got it right that he participated in insurrection, but you got it wrong that the president's exempt under the 14th Amendment. Therefore, we're not going to allow him to be on the Colorado ballot, but we will stay our decision. We'll put it on hold until the federal courts weigh in. And that is currently pending, or it was pending, before the Circuit Court of Appeals for that part of the country. But now the Supreme Court has said, hey, we'll take it from here, boys. So right now the Supreme Court gets to decide whether Donald Trump, A, was involved in insurrection, and B, whether, if so, that precludes his being president. Now, the Secretary of State of our almost neighboring state, Maine.
So hang on one second. So that's Colorado.
Yes.
Where somebody sued and got a case into the federal...
Actually, interestingly, a bunch of Republican primary voters who didn't want him on their primary ballot.
Yes. Sued in Colorado, in federal district court in Colorado. And...
I think it was in state court, actually. Wasn't it in state
You're
court?
right. My mistake. I'm sorry. In state court, under Colorado state law.
Yes.
And then it went up to the Colorado Supreme Court, where, as you said, it was the ruling in the lower court was overturned in part. The part that says that he could be on the ballot got overturned.
Yeah, the part that said that the president was exempt from this rule in Section 3 of the 14th Amendment.
And so that's now headed to the Supreme Court. And there have been lawsuits in a number of other states.
Including Massachusetts. Well, the people said to Secretary of State Galvin that Trump shouldn't be on the ballot, and he said, well, I don't have discretion to do that. A single justice of the Supreme Judicial Court of Massachusetts just said, the issue's not ripe yet. He can be on the Republican primary ballot. We don't care who they nominate, but we will decide later, if he is the Republican nominee, whether he can be on the general election ballot. Because being the Republican Party, but let the Republican Party pick who they want, essentially, and if they pick someone who can't be president, well, that person can't be on the general election ballot. That's what we have basically jurisdiction over. That's what the one justice of the SJC just said in a very short opinion.
Okay. So it'll probably go back to the...
Well, what the justice said is, hold your horses, boys. Let's see what the Supreme Court says about this, because they're going to answer it definitively. Matt, what do you think? I know you're interviewing me on this, but what do you think the Supreme Court's going to say? I mean, not like I'm going to get on the line with my my bookie. I'm going to place my bet. I need your inside information. What do you think that this 9-justice Supreme Court's likely to do? Are they going to keep Trump off the ballot because he tried to overthrow the lawfully elected government of our country?
I think there are a lot of brilliant and eager legal scholars out there filing amicus briefs with the Supreme Court on this topic. I haven't read them all. I'm probably not going to file one myself. Here's my guess. The Supreme Court is going to decide 5-4. No, sorry, 6-3. 6-3. Mm-hmm. Maybe 5-4 if Roberts goes along with the 3 more liberal justices, but I don't think he will. Mm-hmm. either 6-3 or 5-4, that for some reasons, and insert, for want of a better word, malarkey here, it would not be consistent with our nation's long-held beliefs and practices to keep him off the ballot, because it would be
Well, wait a second, aren't those conservatives supposed to be, they're originals, you're supposed to read the letter of what was written. So how are they going to get away with that? If they're going to say, are they going to say he needs to be convicted of a crime first? I mean, there's like three things they could say, right? They could say, he's not an insurrectionist because he wasn't convicted of a crime yet. And you have to be convicted of insurrection. That's one thing they could say. They could say what he did just isn't insurrection. Or they could say, yeah, he did insurrection, but it doesn't apply to the president. What do you have on your game card?
Well, I mean, I think they could say any of those things. I think of those, they're more likely to go with insurrection doesn't apply to the president. I don't think it makes a lot of sense, but I think they could. I think they could also equally well go with what I believe one of the dissenting justices of the Colorado State Supreme Court said, which is that if you look at Section 5 of the 14th Amendment, it says that Congress can enforce the other provisions like that with appropriate legislation, and Congress has not done that. They haven't passed any legislation.
Well, but all the case law on
ever.
But that's a really weak argument because
I think so too.
It's self-executing like so much of.
I understand that. I'm not saying I agree with you, but I think the Supreme Court might pick on that.
They might go for option number 4.
They might pick that out
Okay.
and say, here's a reason that we're not going to. I will offer one prediction, though.
What?
They are going to Bush versus Gore this and say that whatever their decision is,
No precedential
it
value.
holds no precedential value and it can't be used in the future by any future court. And I don't know why I think that, except that Bush versus Gore was a chicken manure decision, and I think this one will be
I
as
was
well.
going to go horse manure, but okay.
Fair. And I think this one will be also. They're going to duck the issue. They might say something like, well, he was impeached and not convicted, so he must not really have insurrectioned or treasoned. They might say that, as you said...
Well, wasn't the whole argument of his lawyers in the impeachment? I mean, they literally said, you can't impeach him. He's not president anymore. The thing to do is prosecute him in court if you want.
Well, what they said in the second impeachment was, this is not something that you can impeach him for, but, if you feel that he's done something wrong, he can be charged criminally.
Okay, which gets to the other case.
But then, of course, once
All right, Matt.
No, but
Yeah.
but I think the Supreme Court has any number of avenues. I will say this about them, although I think some of them are profoundly unethical and perhaps unqualified to hold their positions. They are smart,
Yes.
and their clerks are very smart, and they will come up with some clever reason or reasons why the very clear language that plainly, on its face, both textually, if anybody cares about originalism, which is largely a totally bankrupt doctrine, or by long-held practice, and I use that phrase deliberately because that is the nonsense that the Republicans on the Supreme Court came up with to overturn 50 years of rights to privacy and abortion in Roe versus Wade. They came up with, it's not consistent with our nation's long-held beliefs and practices, which was chicken manure in that decision, and it would be chicken manure in this. But there's lots of ways they can weasel out of this. What do you think, Ken?
I'm not sure about the chicken manure. I mean, I feel like there's a bigger mammalian animal involved. Might be bull, Bucky.
Could be that.
Anyway, yeah. Look.
Let's go with malarkey.
Okay. Yeah. No. I mean, I think that the Supreme Court will. You're right. Say that Donald Trump can be on the ballot. I believe that maybe what they're going to. I mean, I know that there are people who are saying, well, you got to let the people decide who's on the ballot. But I mean, you think about it. What if somebody wanted a 30-year-old to be president? Let the people decide. No, you're just not qualified. You have to be 35 to be president under the Constitution. This is part of the Constitution. You're not qualified under this. So why is it any different than if someone wants to run for president and they're 30 years old? And the Secretary of State says, no, I'm sorry, I'm not going to put you on the ballot. Or the local court says, I'm not going to put you on the ballot. It'll be, what they're going to say is, I mean, I don't know. They're going to argue that they're going to come up with a way. You're absolutely right, Matt. It is to me, though, utter hypocrisy in that the people who are the so-called literal textualists will ignore the actual text. It's also hypocrisy. Let me ask you this, though. Let's go to the second half of the Trump Supreme Court double feature.
But before we do, can we stay on this topic for a sec?
Sure, Matt.
Thank you.
You've got a little cherry to put on top of this.
I want to offer
chicken crap sundae.
Yes, I want to offer a slightly contrarian view, which is going to sound like it's almost contradicting what I was just saying, but drawing on what you just pointed out about, suppose a 30-year-old or anybody under 35 at time of being sworn in wants to run for president. I don't know if that's happened in a serious way. I don't know if anybody under 35 or under 35 at the time they'd be sworn in, because you could in theory be like 34 and 11 months when you're elected, when the vote is held in November.
Of course.
But 35 at time of taking office.
All right.
I don't know if anybody in that age has tried to be on the ballot. But in theory, it seems to me, you could be on the ballot. You just wouldn't get to become president.
Well, I mean, that is not the way. It has happened. It happens all the time with residency requirements. You have to be a resident of the district to run for the office for the state legislature, for example. And there have been lawsuits where the Secretary of State says, you can't be on the ballot, you haven't lived, you have to have 1 year of residence, you can't just move in. So if you haven't been in that representative district for a year, people have said, well, I lived at my mom's house, and they have a fact hearing. No, you didn't actually live there during that time, and you can't be on the ballot. So it happens all the time, actually.
Okay, well, I mean, the mayor of New York, for instance, has had that controversy recently when he was running. Eric Adams.
Oh.
Because he didn't.
Isn't that in New York City? I mean, yeah, well, you mean, right, I'm the mayor of New York.
Mayor of New York City.
Of course.
Didn't seem to actually live in.
Yeah, but what I'm saying is there are plenty of people who are kept off ballots because they don't meet the qualifications. And sometimes there's a hearing on it and whatnot. But I want to go to the second half of this, Matt, because the other thing that the Supreme Court's going to be weighing in on soon, and that Mr. Trump very much wants the Supreme Court to weigh in on, is whether he has complete and total immunity as president for things he did as president of the United States. And I loved the oral argument in that case where this was before the Fed Circuit Court of Appeals, where the judge asked him, ask Trump's lawyers, if he ordered SEAL Team 6 to assassinate a political opponent, would that be okay? Could he be prosecuted for that? Because with their argument is, well, official acts he can't be prosecuted for, and that's using SEAL Team 6 would be an official act. Right. And his lawyers tried to weasel out of it by saying, well, if he was impeached first, he could. He'd have to be impeached, was their argument. What do you think is going to happen with that case, Matt? Is Trump going to get full immunity by the Supreme Court, or will they split the baby, let him run for president, but not give him immunity?
I think that's what they'll do. I think they'll let him run for president. I don't think they'll give him immunity.
Okay, which gets to the $10,000 question.
Or $83 million question. Sorry, it's just to pick a random number.
Yes. 83 and a third, 83.3 million. What happens, I was just thinking about this, if the Supreme Court says, okay, he needs to be convicted, he can be on the ballot for president because he hasn't been convicted. Then they say, but he can go, he can be tried for these things he's been accused of. Then he gets convicted of the January 6th related crimes in federal court before a jury of his peers, and then can he run for president at that point once he's been convicted? In other words, could theoretically the Supreme Court write their opinion on the first question in such a way that the trial on the second question determines whether he can be on the ballot?
Yeah, it's possible. I don't think that's what should happen.
You don't think that's what should happen?
No, what I think should
What should happen, Matt?
What I think should happen is that the Supreme Court should look at the Colorado case and the Maine case, which you started to describe, and then I interrupted you. And we should tell our viewers about it. I think the Supreme Court is going to look at them and say he's eligible, he can be on the ballot. But what they should do is say, look, the court in Colorado held a finding of fact. The Secretary of State in Maine held a finding of fact. They both found, within their totally reasonable and normal judgment, that he engaged in insurrection.
So wait a second, Matt, are you saying that the Supreme Court should sort of punt on it, it'll be on the ballot in some states but not in other states?
I don't think that's what they should do.
What do you think they should do? You're on the Supreme Court. How are you voting on this?
I'm looking at the text of the 14th Amendment.
Yeah, and what are you saying?
I'm walking through it one at a time. He took an oath as an officer of the United States. He engaged in insurrection against the United States, and he gave aid and comfort to the enemies of the United States. He should be barred from holding any office, period, forever, under the United States. President, Vice President, Senate, House, anything. Anything that is an officer of the United States.
Or as a member of any state legislature. He could still be mayor of New York City, by the way.
Good luck. I don't think New York City likes him all that much anymore.
Yeah, well, maybe mayor of someplace in Florida or something. I don't know.
Sure, yeah, West Palm might vote for him.
Actually, I don't even think it says governor. He could probably be he could be governor of Florida, maybe. Anyway, so Matt,
that's what I think should happen. The Supreme Court should say,
but you don't think
he's not eligible to hold any office.
I think it would be absolutely fascinating if they set this up where there was a trial to determine whether he was an insurrectionist, and then if he was an insurrectionist, he was convicted essentially in the special counsel's prosecution. Then he could.
Yeah, you mean somebody's trial.
I mean in the trial. Yeah,
the ones that are running now.
The big federal prosecution. Yeah. It's a real simple case, basically, that he tried to,
One of the hard things with that argument, though, is that the acts here are, common terms. They don't point to any specific crimes. And the crimes that he's charged with are mostly crimes that were created after this amendment was written.
Well, I think that
it's hard to point at this section of the Constitution.
I think you could have a universe of crimes that count as types of insurrection, and I think what Donald Trump's accused of should fall into that category. Trying to steal the election in that way.
Ken, I agree.
Trying to kill your vice president to stop him from participating in certifying the election results.
Urging people to kill the Speaker of the House. To overrun.
I think that's pretty much that crime. I mean, things can be more than one thing, right?
But that's the tricky part.
A cucumber can be both a vegetable and a fruit.
Okay. Yes. That's the hard part with saying that he's got to be convicted of a crime of insurrection. There isn't, as I understand it, exactly a crime of insurrection, and not as this amendment was written.
Yeah, and I don't think that matters, though, Matt.
I don't think the Supreme Court is going.
I don't think they're going to do that.
Up.
I think that would be interesting, though. I think it would be.
It would be interesting.
It would be a kind of a compromise, right? There was a day and age in this country where compromise was more of a thing. Now everything's kind of black and white, us against them. Yeah. But anyway, there used to be you can read books about the negotiations that used to take place on the Supreme Court and how they'd, come up with some.
If you read even recent books, by current journalists about the current Supreme Court, or just a few years ago, it sounded like even across what you and I and outside viewers see as ideological lines, they still were a fairly collegial group, and they'd collaborate behind closed doors. They'd work out compromises amongst themselves. I don't know if they're still doing that. I have no insider knowledge of that. But it's hard for me to see what sort of compromise they're going to strike on this issue.
I don't think they will, Matt. I think they could, is all I'm saying.
They could. I think that would not be the worst outcome possible. Because I think they could also say he didn't engage in insurrection.
Yeah, well, I think
he's
they will.
Fully eligible.
I think they will. But I'm just saying it would be a good sign for our country if our institutions were more oriented towards working together cooperatively and not beating up the other guy all the time. I mean, look at the way the Republicans in Congress are behaving. They'd rather, shut down the budget, in other words,
Shut down the government. Default on our loan payments.
Yeah, but then make some compromises on their fiscal priorities. They have a narrow majority in the House. They don't control the Senate. They don't control the White House. In normal times, they'd be like, okay, we've got some influence. We have the House speakership. We'll negotiate and we'll use our leverage. Now it's, sabotage the whole thing, shut it all down. I blame Newt Gingrich. He started this.
I think that's fair. Yeah, I agree.
Anyway.
I know you and I often look for something to disagree about.
Yeah, I know.
Because it makes it more entertaining, but I agree. I think Newt Gingrich is very much to blame. Not only him.
Yeah, no. I don't. You can oversimplify, but I mean.
But I think a lot of it started.
He built the template, I think, to a large extent.
Yeah.
Anyway, you know what we have? We have something very exciting for our viewers.
Yeah. Let's before we move on, let's just say we're going to try and have a show in February. The Supreme Court is supposed to hear the Colorado case, I believe, in early February. So hopefully we'll have some updates to report on about that topic.
Oh yeah, there will be so much going on. And by the way, people may hear about these things on the national news and in the New York Times, but they aren't going to get the quality of puns on those newscasts or food analogies that they're going to hear right here on Legal Angle with Matt Yaspin and Ken Parker. There's just no way. I challenge Rachel Maddow to make pickled puns. I want to hear it.
Yeah. Ms. Maddow, don't be sour. We love your show.
You could be half sour if you want, but.
All right, Ken. I know we threw in a bonus topic.
Yeah, we've got a bonus topic. I love bonus topic.
Yes.
And this is a really good one too, Matt, because there is, we were talking about an $83 million settlement. There is an $80 billion company. And as far as I can tell.
Do tell. As the late Senator Everett Dirksen said, $1 billion here, $1 billion there. Pretty soon you're talking real money.
Yeah.
So 80.
$80 billion.
That might be real money.
Yes, well, it would be real money, except I think it's more in the Jesse James line of, why do you rob banks? Because that's where the money is. There is an argument that this company has $80 billion of worth, largely on the backs of stealing other people's intellectual property. And of course, we're talking about the company we've talked about before, OpenAI. And OpenAI was sued by a number of members of the Authors Guild, including some very famous writers, like the guy who hasn't written Winds of Winter yet. You know what I'm talking about?
Is that George Martin?
George R.R. Martin.
George R.R. Martin.
Not to be confused with the Beatles producer, fifth Beatle guy.
Oh, sorry.
All right.
Other George Martin.
That's why he gets his R.R. I think. R.R. Either that or he's a pirate. R.R.
He could probably pass as a pirate, Ken. I don't know if you've seen photos of him.
Yes, I have.
Yeah.
Anyway, so the deal is, you and I, Matt, have talked about how he's ingested, how OpenAI has ingested entire novels and can basically spit them back out again and could write a sequel and summarize and what happens in chapter 3. They can describe in great depth what happened. These are all copyrighted works. Well, they've now ingested something else, the Gray Lady, and the Gray Lady is not happy.
Oh, no.
And
I know, the Gray Lady, it's the New York Times.
Yes, of course.
So what's happened? What's the new lawsuit?
Well, apparently, the OpenAI model they call it training. They don't call it infringement. They don't call it copying. They call it training. Training sounds much better. We should all do some training.
Yeah, that's a really good choice.
Yeah, next time that'd be like, I'm not robbing the bank. I'm training on using its money. I love that. It's just,
I wasn't speeding, officer. I was training for Daytona.
Yeah, right. There you go. It's like that could work in so many life situations.
Oh.
Honey, I wasn't cheating. I was training on.
No, we're going to cut this off right now. Let's go back to the New York Times.
Anyway, all right.
So the New York Times.
Yes.
And OpenAI training its models.
Yes. OpenAI was using, apparently, has copied all of the articles in the New York Times archive, and doesn't have a license to do so. And so the New York Times found that it was basically republishing their material that they're paying their reporters to publish, and they're saying, hey, look, people aren't buying subscriptions to the Times. They aren't Times monetizes a few ways. One way is through its Wirecutter section, where they get a cut when people buy things that they have articles about in Wirecutter, and they're saying, we write an article on Wirecutter about a good,
Yeah, the best toaster.
power saw or
Yeah,
something.
whatever.
And then OpenAI writes an article which appears on the web for free. People go there, and we lose the monetization. Not only that, but at some point you're not going to be able to pay reporters if people don't need to subscribe to the Times and can get the Times content somewhere else.
How did the New York Times find out about this?
That's a good question.
Did they make it clear in their filing?
Yeah, I mean, I trying to remember, but I think that they, I don't think that OpenAI is denying that they trained. I'm pretty sure they're admitting they trained on these Times articles.
Wow.
They're just saying they have a right to do that. That's not really the controversy in the lawsuit.
Oh wow! So what is the gist of the suit? What are they alleging?
Well, they're alleging copyright infringement.
I mean, but what are they?
What is the defense?
Yeah.
The defense is essentially fair use. I mean, they're saying, well, the argument is as follows. Well, Matt, if you were to read a bunch of articles, you could still write a blog post based on your knowledge that you gained in the. And by the way, you read a lot of books, right? And that's how it makes you such a good writer, because if you hadn't read anything, you wouldn't be a good writer. So all our model is doing is just reading things. But the difference between a computer reading things and you or I reading things is the computer can spit back out every single word. So if you ask OpenAI, give me chapter 3 of Game of Thrones, it can just spit out the entire chapter, because it does contain a copy. Now it's encoded in hexadecimal and everything else, but it's still copying. And to me, here's the thing. A lot of people who have been upset by what OpenAI can do have been focused on the output side. Well, it would be infringing if they reproduced an article from the New York Times, or if they reproduced a story by George R.R. Martin. And to me, you don't have to go that far. What's more important, frankly, is copying the source material, the training process. Because at that point, even if, say you were to copy all the great, copy lots of articles, lots of books, and then come out with something that was, quote, new based on that, you're still making use of it. You're making, that training is involving copying of it.
Yeah.
And to me, it's that act that is the infringing act. And I think, we talked before about 5 million or 83 million. I mean, this is about whether there's going to be journalism left in this country. This is an $80 billion question. It's a $80 trillion question. You cannot let OpenAI do this. I hope the New York Times wins this lawsuit, and OpenAI has to pay licensing fees, because otherwise there will be no economic model for supporting journalism in this country. And without journalism, without a free press, there's no more democracy.
Yeah. Well, Ken, I agree.
Well, can't we have a fist fight or something? At least make a few jokes about it.
I can ask OpenAI to write me a response and rebuttal. How about that? And when we're back in February, I'll tell you what it says.
Oh, good. I can't wait.
Yeah.
That'll be a good, yeah. It's, and while you're at it, you could have it, make up some pictures. Maybe, ask it to create some mice.
I'm going to ask
some
it
cartoon mice.
I'll surprise you. Ken,
Okay.
I know we got to wrap it up, but it's been a real pleasure.
Yes.
As always, it's fun.
We got the year off to a good start, didn't we?
I think so.
I hope our audience enjoyed it.
I hope so. Always
Yeah.
a pleasure. Lovely to see you.
Yeah, it's a good break from all the crap going on in the world, and the crap has seeped down to Newton too. So
It's just it's been quite a month,
Yeah.
and it's not even over.
no.
But
yeah.
thank you very much to all the folks in the studio here at New TV and in the control room who make this possible. We could not do it without you, and we appreciate you very much.
And John Freemer is directed today. Thanks, John. It's John's first time directing in a while, so fabulous job, very smooth.
Yeah.
Thanks to Aiden and Oksana and everyone in the studio, everyone at New TV. And thank you at home for watching. And please join us again next time in February, when we try to talk about some issues in the news.
From a legal perspective.
What other way is there to do it, right?
I wouldn't know.
Anyway.
Thanks, Ken.
Take care. Good night.
Good night.